want to see that warrant.
What?
I want to see the warrant. You're supposed to give me a copy.
Yeah, well, my partner has it. He'll be out within a sec.
Hey everyone, this is Eddie, and welcome to this review of question 6 of the California bar exam that was administered in February of 2017. So what do we have here? We have criminal procedure and criminal law. Let's go straight to the questions. And let's see, question 1 has 2 parts. Let's break this down. Let's talk about cocaine. That's oppression of cocaine under the 4th Amendment. And it seems as if Debbie wants to suppress the cocaine, and she wants to use the exclusionary rule under the 4th Amendment. So let's talk about this very briefly. And there's a lot to discuss here, and I'm going to keep, time is going to definitely be very important here. So let's go ahead and go through this. Let's talk about standing. It seems like that Debbie does meet standing. And let's go to the arrest warrant. So you guys know that in order for a magistrate to sign that, it does require probable cause. And police, they can use an informant to establish probable cause. That's nothing out of the ordinary. However, we have something different here. We have Ivan, and he's proven to be unreliable. So that's not going to help. And then to complicate matters for the government, the detective that signs the affidavit commits fraud by saying that Ivan was reliable. So I'm going to say that the arrest warrant is not going to be valid. But that does not end the discussion. We have the good faith exception. And what does that say? That says that the exclusionary rule may still not hinder police from introducing evidence when the officer relied in good faith upon a defective warrant. So what I want to know is this. I want to know if the police did indeed rely on a warrant. Now I'm going to go to the actual question here. And what I did was I wrote down the word obstacle there, because it didn't seem right to me that the police, they had in their possession an arrest warrant. And what do? They go on a fishing expedition instead of just going straight to Debbie and arresting her. So I definitely highlighted that, and I did focus on that. And of course, there's more information on how to apply these obstacles here on your writing on this source here. But let's keep going. So how does an officer rely on a warrant? So they must serve a copy to the defendant. And here it seems like, the facts state that Bob never gave Debbie a copy of that warrant. He never even said, hey, there's a warrant for your arrest. And the police can do that, but if they do that, they must then present probable cause through independent sources. And let's see if there's probable cause there. And we know that officers, they can't arrest a person if that person commits a felony in their presence, and then of course an arrest can take place. So I'm looking for that, and we might have here a solicitation on the part of Debbie, and if that happens, and then of course that can merge with the completed offense, and that can lead to a felony. So I'm going to see if there's a solicitation present here, and based on the encounters, on the dialogue. So first we have Ivan's allegations, and I'm going to say that that's not going to be very useful for the police to establish probable cause, because Bob was not there when Ivan stated that Debbie had offered $2,000. So now let's go to that meeting between Bob and Debbie. And the first thing that Bob says is this: I understand you're looking for someone to kill your husband. And then she says, I've changed my mind. And then you could definitely argue that Debbie there was not trying to solicit a murder. And now I want to know if there is a conspiracy. Now here with these arguments here, you can definitely argue both ways. And again, that's what the bar graders want you to do. They want to see your analysis, not so much your conclusion. So earlier I did say that there was no solicitation on the part of Debbie. Was there a conspiracy? Let's go to that now. So what do we need there? We need an agreement, specific intent, and an overt act. Again, analyze the heck out of the facts. And even if there is a police officer, one of the parties is a police officer, you can still have the crime of conspiracy. That does not merge. So that could also be a felony. And you could say that the $200 payment that Debbie said was going to go towards down payment, that could present an overt act. And of course, you can say that she wasn't sure and specific intent is not met. So you just got to argue that. I'm going to say that because Debbie says she's not sure, and then the elements are not met because intent is not present there. So I'm going to say no conspiracy. Plain view. So the officer does find a powdery substance, but that was after the officer arrested and searched Debbie. So I'm going to say no. No, it's not going to be in plain view. Exclusionary rule. Okay, under the fruit of the poisonous tree doctrine, the exclusionary rule will prevent the cocaine from being admitted. Okay, now let's go to that second part. And what does that second part say? It says, let's see now, motion to suppress Debbie's post-arrest statement under Miranda. So now we are going to talk about Miranda versus Arizona. Let's see now. So of course, talk about, okay, so the statement, she says it's cocaine. I guess I'm in real trouble now. And of course, if a person is arrested, and then the officer must read in the rights, standing. Okay, interrogation, let's talk about that. Now I want to know if Bob's question was that an interrogation, and that is defined as such. It's likely to elicit an incriminating response on the part of the defendant. Now we also know that Bob did not read the Miranda rights to Debbie after the discovery of the cocaine, and he says, well, what have we got here? So that's going to be the focus of this analysis. So it could be that it's a rhetorical question, right? Well, what do we have here? And you can definitely argue that it wasn't meant to elicit an incriminating response. But you could also argue the other way around, right? You could also say that it was meant to elicit an incriminating response, because remember, Debbie's just been arrested and she's been handcuffed, and she's kind of went through this whole ordeal with arguing and being persuaded to go through with the killing. So I would say that she could feel disoriented, she could feel confused, and that statement is likely to elicit an incriminating response. Do we have waiver? Waiver is present when it's made intelligently and voluntarily. And here, as stated above, I don't think that Debbie made a waiver. So the conclusion is that the post-arrest statement will not be admissible. Let's go on to question 3. What do we have? Question 3. Okay, the question that deals with the defense of entrapment. Okay, let's talk about that very briefly. So what do we need there? Okay, we need to show that the government induced the crime and that the defendant was not predisposed to commit the criminal conduct. So now I want to know if the government induced the crime. So in order for that to be present, and then there needs to show persuasion on the part of the government and moral coercion, urgent, or harassment on the part of the police. So let's go through each statement that is spoken by Bob. He says, "I understand you're looking for someone to kill your husband," and that does not seem like it's an inducement. It seems like it's more like it's opening. It's an opener for a conversation. And then she responds with saying, "I was, but it's too risky. I've changed my mind." And then he says, "That's silly. It's not risky at all." Now that kind of sounds like it's an extraordinary promise, because Debbie's saying it's too risky, but Bob is suggesting that maybe Debbie can outmaneuver the law and not get caught. So that seems like coercion. And again, Debbie does say that she has changed her mind, and Bob says, "Hey, look, I'm promising that there's no harm of getting caught." So Bob does seem like he's exploiting Debbie's fear, because again, she says it's too risky. So it does seem that the government is putting into place an act of coercion here. And then for the third statement, Bob says it's now or never. And that kind of sounds like it's just harassment on his part. So I'm going to say that there is inducement on the part of the government. So far so good for Debbie. Now, here's another question here. Was Debbie predisposed to commit the crime? And there are some factors there. Let's go through those factors. Whether the defendant demonstrated reluctance. So we know that even Bob had to say, okay, it's now or never. So that means that Debbie did not immediately accept, and she does make a down payment, left that option open, but she did say that she wasn't sure. Okay, and then, okay, let's see now. Well, the government initially suggested the criminal activity. Okay, so Bob does open with that question, and that could help Debbie. Okay, and then of course we have the nature of the government's inducement or persuasion, and it's mentioned earlier that Bob, it seemed like he was even harassing Debbie. So I'm going to say that the 3 out of these five factors that they favored Debbie. So I'm going to say that she was not predisposed, and you could say, but Debbie did agree to meet with Bob to discuss the killing. And I'm going to say, hey, it is possible that she changed her mind after that initial phone call with Bob. Okay, and you can say otherwise. Okay, you can make your argument otherwise. Again, the analysis is the focus, not the conclusion. And moreover, the facts state that she agreed to meet with Bob. And this could show intent. But remember this, that a person can have intent and still be entrapped. So this will not help the government. The conclusion, Debbie was not predisposed, and the defense of entrapment will be available to Debbie. So I hope this helped. Until soon.